Welcome to the Animal Law Podcast. This is Marianne Sullivan. I have a great show for you today. I think you're really going to find this fascinating. I'm going to be speaking with Kim Richmond of the Richmond Law Group. And this conversation is about a number of different cases he has brought, which involve such things as the use of antibiotics in animal agriculture. We're going to be talking particularly about poultry production, and also how that relates to certain advertising claims, including the use of the word natural. And what does that word really mean when it comes to food? And what do people think it means when they hear that something is natural? This is a fascinating conversation about a fascinating series of cases. I am so glad that we were able to connect with Kim for this conversation. I think you're really going to love it. Before we get to that interview, I'd just like to remind you that running our hen house, which produces this podcast along with the Our Hen House podcast, it's something we absolutely love doing, but we do need to ask for your support from time to time. And if you can offer some support, just go to ourhenhouse.org/donate. You can either join our special band of supporters, whom we call our flock, or you can just make whatever donation you can afford and are comfortable with, but it would really help us out if you could do something. The only way to keep animal-friendly indie media going is through supporting its efforts. And in this case, we really think that Our Hen House and the Animal Law Podcast we think we're deserving of support. We hope you do too. But now to Kim Richmond. Kim founded the Richmond Law Group, which is a boutique firm in Brooklyn, New York, in 2015. And the function of the firm is to use, I love, this is right off their website, and I love this expression, to use law and policy to repair the world by litigating on behalf of everyday citizens, parents, activists, nonprofit organizations, progressive businesses, and trade associations. Isn't that, wouldn't you like to work for a firm with that description? I love that. So he started his legal career at a class action securities firm and a criminal defense firm, and then ventured out on his own. And before he engaged in impact litigation at the Richmond Law Group, he ran a practice focused on civil rights and consumer protection cases. So he's well steeped in the topics that we'll be talking about. He has a deep interest in food, agriculture, and the environment. And he lived in, this is an interesting fact, he lived in the great outdoors for a year while in college, traveling on a school bus throughout the American West, studying consensus models, deep ecology, Native American culture, and food systems. So he's a pretty cool guy. And I think you're really going to enjoy this interview. Welcome to the Animal Law Podcast, Kim.
Thanks, Marianne.
It is really a pleasure to have you on. We've been trying to put this together for a while, and finally I've got you because I'm excited to be talking about these cases. But before we talk about the cases at hand, can you tell us a bit about your firm and about the kind of work you focus on?
Sure. From the Richmond Law Group, we are based here in Brooklyn, New York. We're also out in California and in Washington, D.C., all the places that have the strongest consumer protection law. I have historically done consumer protection class action work, and I've been regarded as a food litigator of sorts. And over the years, we have targeted a range of issues, from trans fat to GMOs to pesticides, antibiotics, and now all things contaminants.
We're actually going to be talking about a bunch of cases today. Normally I focus on one case, but all of these cases have a lot in common. There's a case brought by Direct Action Everywhere against Diesel Turkey Ranch. There's a case against Sanderson Farms. There's a case against Hormel. So can you tell us a little bit about the overall issue that ties all of these cases together?
Sure, and it's frankly very simple. It's truth in advertising. So historically, we have brought cases against companies that purport to be all natural, 100% pure, all the various marketing schemes that we have seen emerge over the years. And we first focused upon trans fat. And there were statements of healthy and 0 grams of trans fat, and we had found otherwise through testing. And so we were unsure how this would be received by the courts. 6 months after we filed the case, New York City had outlawed it in restaurants. LA had followed. And we ultimately resolved the matter along with a whole host of other cases The science was emerging that trans fat was bad, and we were successful in many cases in terms of removing trans fat from the product and setting up cypre funds that were earmarked for organizations such as the American Heart Association. And that was what set us on this trajectory. And so we had a tremendous amount of success in terms of effectively getting ahead of a public health issue before, say, the FDA finally got their act together, who just recently, this is now a decade after our suit was filed, finally deemed trans fat unfit for human consumption. So here we found a creative way to use consumer protection class action law to address these larger public health issues when, in fact, government could not get their act together.
And what is the claim and the problem that you're addressing in these cases? Because you've moved on from trans fats, having won that fight.
That's right. And we then focused on GMOs, and we're able to, frankly, make significant changes to products before any state initiative ever had the chance to, since, of course, then ultimately the Dark Act came down and there was preemption as to how products now need to label themselves that contain GMOs. We then started focusing on pesticides and started looking at products that contain namely Roundup or glyphosate, and everyday products from granola bars to oatmeal to whole wheat bread to honey, orange juice, etc., and have found, unfortunately, that our food systems are indeed adulterated with glyphosate and have been pursuing those matters. And so that then brings us to antibiotics. And so historically, yes, we would work with a host of labs who would do testing. It was very straightforward in terms of testing for trans fat, GMOs, and pesticides. But when it came to antibiotics, it proved to be a little trickier for our labs to detect it. And so as we have, in fact, become more aggressive in terms of our investigations, we then, of course, part and parcel now issue FOIA requests. And through a host of FOIA requests, we then were able to secure a data set of information from the National Residue Program, which was part of FSIS, USDA, and they apparently, as a matter of course, collect data from a whole host of various potential contaminants that may pop up in conventional meat. And so it was based upon this information that we were able to further propel the litigation that we have historically done using truth in advertising.
You point out that you got this residue, I think you called it residue information. And this one thing I found really, really interesting about this case is that, I know that the use of antibiotics causes a lot of harms, but I generally think of it as the fact that it causes the growth of antibiotic-resistant bacteria, which can affect anybody. But that's not what you're suing about, right? You're focusing on people are actually consuming antibiotics and other pharmaceuticals or maybe some other toxins when they eat these quote unquote foods. Is that right?
That's correct. And so this raises, of course, an array of issues from, of course, our human health to questions around animal protection, the environment, labor, and issues around antibiotic-resistant bacteria. That obviously is of real concern, but is one of many issues that we are effectively trying to address through this litigation. And so we have basically formulated what we refer to as this kind of trifecta approach, wherein we can address a whole host of issues that are implicated by these companies that are otherwise purporting to be all natural, but do in fact contain a host of contaminants. And so let me be clear that these cases are not administrative actions. This is not where we would bring an action against, say, the FDA or USDA or EPA to compel them to enforce a violation. These are private rights of action. And typically, we have brought these as consumer protection class action suits, but for a host of reasons, we have been litigating these as consumer watchdog cases. And so I think it's perhaps helpful to further explain that under the Trump administration, there has been, of course, an uptick in folks taking matters into their own hands as the government has grown paralyzed. And so a lot of consumer watchdog groups have frankly given up, pursuing change vis-a-vis, say, a legislative process, and have realized, much like other movements, that perhaps our judiciary is our last hope in terms of maintaining a balance of power. And so very much within that vein and that trend, these nonprofit groups have been stepping forward and have been, frankly, acting as, in a sense, a mini EPA, a mini FDA, and a mini USDA. And so groups, ranging from Center for Food Safety to Organic Consumer Association, Friends of the Earth, Beyond Pesticides. These are all folks who have stepped forward, whether it be in the litigation pending in D.C. or in California. And so it's a unique time for folks to really take matters into their own hands, and courts are frankly recognizing that they do, in fact, have standing, which is a unique phenomena that we are experiencing here under the Trump administration.
Yeah, I really want to get into the standing issue because I think it's really interesting. But before that, I just want to go back for a second because you said you got this information from FSIS, the Food Safety Inspection Service. Is it that they're not enforcing, so they know these adulterants are in this food, are they not enforcing their regulations, or are these adulterants simply not in violation of any laws or regulations?
The latter, and allow me to clarify the difference between legal and unlawful. And so, of course, if these contaminants rose to a certain level identified by the FDA, they would then be in violation. Now, whether or not there is enforcement mechanisms in place is another question. But given that a lot of these contaminants were deemed to be, according to the government, residue, no further action was taken under a lot of these antiquated federal regs. But with the truth in advertising legal theory here, where it's a reasonable consumer standard, when a product purports to be all natural and contains any level of contaminants, we have deemed that to be unlawful. And that is a very important distinction, one which that certain folks have tried to conflate. But this is something different. I think that most reasonable consumers who see antibiotic-free or all natural would, in fact, deem any level of, say, antibiotics, hormones, pesticides, heavy metals is frankly just unacceptable. And that is what we're seeing here. And that's how the data is being implicated in these truth in advertising suits.
Yeah, no, I think this is vitally important because we clearly can't just be relying on the government to be policing this, and the fact that they're telling people that this is all natural. Now, the foods, the quote unquote foods that we're talking about are chicken, turkey, and eggs. Is that right?
That has been the subject of our litigation as of the last couple of years. Yes.
So let's get to the lawsuit. So before we get to the term natural and the adulterants and all of that, let's start off with standing, because standing is always of interest to animal lawyers. And as you pointed out, your plaintiffs aren't consumers; they're not-for-profit organizations. So what is your basis for standing and in filing a consumer protection lawsuit?
Sure. So in Washington, D.C., the Consumer Protection Statute had been amended in the last few years to give statutory standing to nonprofits. And that is extremely unique, wherein an actual statute gives nonprofit standing. California, back in the day, had similar provisions, but that had then since been changed under Prop 64. And so D.C. is a very unique place these days, and you've seen a whole host of nonprofits pursuing action in D.C. Superior Courts and in D.C. federal courts. In California, on the other hand, the standard for standing is pursuant to the Supreme Court case, Havens Realty, where you have to demonstrate that the plaintiff, the nonprofit in this case, has diverted resources. And that is not a statutory standing, but rather a different form of standing under the case law. And we have been successful in certain matters in establishing that heightened level of standing.
Yeah, I think probably a lot of our listeners are familiar with Haven standing because it's so often used in animal law cases. But as you pointed out, it has to do with an organization arguing that they've diverted resources because of this violation of the law. And, I know we're talking about a wide variety of different cases and different organizations here, but can you just kind of factually lay out like how those resources would be diverted, give an example or just an overall view of what an organization is forced to do as a result of these companies violating the law?
Sure. And so we have a broad reading that's consistent with the case law, wherein if an organization is diverting resources to, say, address antibiotics in our food systems or perhaps CAFOs, we have found that courts have adopted that as a sufficient basis upon which they've diverted resources. Defendants, on the other hand, of course, take a more narrow read and say, well, has the nonprofit, in fact, diverted resources in targeting the specific product in question, or even the specific statement in question, the all-natural antibiotic-free statement? And courts have been reluctant to adopt that narrow reading at this point. And so what we have seen, in fact, courts willing to adopt not only this broader reading, but frankly, a slightly more progressive reading, that here are, again, environmental organizations, animal protection organizations, human health organizations that, of course, are addressing antibiotics and contaminants within our food systems on multiple levels, and have been able to, frankly, proceed forward at this juncture with their cases.
Yeah, no, the use of Haven standing here seems to be hugely valuable, but I've never really looked at a case before where it's being used in a consumer protection, like a false advertising case as yours. Does it differ? Does the way you litigate differ when your plaintiff is a not-for-profit rather than a consumer has been harmed?
It is litigated differently, especially within the context of meat companies. And so while historically we have brought consumer protection class action suits where we target the label, when it comes to meat products, it is a slightly different terrain. It is an expressly preempted terrain when it comes to the label. And so this is something that we've had to thread the needle over the whole range of these cases, wherein we have not touched, believe it or not, the label itself. That FSIS, believe it or not, has in fact, for instance, defined all natural, unlike the FDA is in the process of perhaps defining. And so given that FSIS has, for instance, an explicit definition as to what all natural means, it is expressly preempted, meaning that you can't even touch it. And so while we've been successful in the past navigating, say, organic integrity issues, food label issues, when it comes to meat products, so long as it has that FSIS stamp of approval, we have been unable to touch the label. So accordingly, we have targeted everything but the label and have focused primarily upon the marketing and advertising, and have brought these as consumer watchdog suits, which are technically on behalf of the general public versus, say, a class of consumers as you would typically see in a class action consumer suit.
So what's the difference between a label and an ad?
And so, for instance, right, websites, commercials, brochures, everything but the label. And so it's important that we, steer clear of the label. We have attempted to push the envelope. There have been successful efforts by defense counsel conflating say the label with, say, brochure, saying that the brochure is just an extension of the label and therefore is equally preempted. But at this point, with regards to websites, commercials, etc., that all falls within the bucket of advertising and marketing and does not, frankly, get sucked into the preemption presented by a label.
Yeah, I mean, it's really good that you have this distinction. I have to admit, it seems a little crazy, this distinction, but that's what the law says. So there is an opening for a lawsuit here, even though the federal government has allowed this this labeling, which I think is arguably deceptive. But let's get into that, into the actual substance of whether it is deceptive. It sounds deceptive to me. Anyway, let's get into, as I said, let's get into the substance. And can you just briefly describe the statute? You mentioned D.C. statute and California statute. What are the requirements to state a cause of action? And all of your causes of action are for false advertising. Is that correct?
That's correct. And so, again, truth in advertising, we rely upon state consumer protection statutes, false and deceptive advertising statutes. And so whether it be D.C., as I mentioned, or the whole array of statutes in California, New York as well. Each state has their own consumer protection statute. And so California being the most developed, most robust, and comprehensive. But it's just relying upon, basic state statutes and often, nonetheless, able to be litigated in federal court if there's diversity, et cetera. And so there are matters that are pending in state court or in superior court in D.C., but we have also litigated cases in federal court using state consumer protection statutes.
So what are the requirements to state a cause of action? I know these statutes may differ a bit, but in general.
So in California, it's not only a question of whether or not it's false and deceptive, it's also a question of, is it likely to deceive? And so the standard really is this reasonable consumer standard. And as people's consciousness around food has just been exploding, right, ever since, say, Michael Pollan has been writing on the issue, or Mary Nessel, the consciousness around what is in our food, from GMOs to gluten, et cetera, has exploded. And accordingly, the reasonable consumer standard has grown increasingly more sophisticated. Unfortunately, with regards to all natural, it has been abused by corporate America, knowing full well that resonates with consumers who use that as a shorthand in terms of determining whether or not the food is healthy or safe or free of antibiotics, for this matter. And so this is a very interesting time. For instance, one of our cases is pending in San Francisco Federal Court in Northern District of California, which has been regarded as the unofficial food court because of this proliferation around food litigation. And so this is, I think, frankly, just reflective of the fact that people really do care about what's in their food.
Yeah, I bet reasonable consumers in San Francisco are very educated. That's such an interesting thing that you pointed out, that consumers have become so much more educated about what's in food that the reasonable consumer test has shifted to a more sophisticated test.
That's correct. And, it's really a question of fact. Although defendants often like to argue that this is a question of law, what a reasonable consumer would expect when they see statements such as all natural, and say that it's just simply not plausible, that anyone who sees all natural would believe that it's free of certain contaminants. But the reality of the matter is, in the case law, by and large, supports this question of fact that is really up to a jury to ultimately determine. And so oftentimes with a lot of these cases, the first major hurdle is a motion to dismiss, wherein sometimes certain courts do say this is, yes, a question of law, it's just not plausible, and therefore the case is dismissed. However, if the law is properly read, it really is a question of fact, and the case should proceed forward past the motion to dismiss, which is in fact, yes, the first major hurdle in most of these cases.
Yeah, as you're pointing out, it's a question of fact what the reasonable consumer, something that I think gets confusing here, what a reasonable consumer thinks natural means. And then there's also, is the word natural defined by regulation in other contexts? And does that get confusing?
So typically it's not defined. FDA has taken up the question, but has been sitting on the issue for now years. And so at this point has not been defined. It has not been regulated, and there's no rulemaking or federal regulation when it comes to statements such as all natural outside the meat context. And so that's why there has, in fact, been, yes, a proliferation of cases, so much so that courts have been regarded as unofficial food courts. But again, FSIS has defined it in this case, and it's been expressly preempted, so the labels are not directly targeted.
Right.
But it has been interesting to see how the courts have, in fact, been able to step in as a result of the fact that the government has failed, frankly, to really protect the food systems from being adulterated.
The word natural has been litigated in other contexts outside of the meat context. What would you say is kind of the overall state of the law regarding what natural means?
And so there is a great body of law that's generally favorable when it comes to these false and deceptive food cases. And so that body of law, has effectively been helpful in terms of us moving the needle in the meat context. And you have, case law out there that, clearly says that labels matter, that what representations that a product makes is material, that people, when they are, for instance, shopping, that they should be able to rely upon the statements that these companies make. Williams v. Gerber is one of the seminal cases in California, and there have been other courts, for instance, in New York, that have followed this rationale, that it's really almost believe it or not, the court has said a hurried shopper standard, that person who comes into the supermarket has nothing else but to rely upon what a product purports to be. And so they should not have to, for instance, turn even to read the side of the box or the back of the box to find that the statement is, in fact, not entirely true. Yes, nowadays folks are extremely sophisticated in understanding what they're buying, but nevertheless, the research has shown from, say, Consumer Reports that when people see all natural, they, in some cases, believe that it's perhaps the same, if not better, than organic. And companies know that. They have done extensive market research. When it comes to, of course, advertising and marketing, they're very strategic in terms of what they're putting out there, and they realize the value of saying all natural to the consumer base and general public at this point in time. And they're willing to take a risk, even if it does mean that they become a lightning rod and the subject of litigation, that they are willing to take that risk. And they're doing basically a cost-benefit analysis at our expense.
Yeah, I think that clearly shows. They can't have it both ways. That must clearly shows that this word is valuable to them because consumers do rely on it. And
that's right.
Have you've done research showing that consumers do rely on it? Is that right? It's not just you saying this; it's people, right, have responded.
That's right. And typically we would perhaps retain a survey expert who would assist us in assessing a specific statement and how deceptive it may be. But there is, of course, tremendous amount of research. As I mentioned, Consumer Reports has extensively done research as to how folks are, frankly, confused by the statement all natural. And that, in fact, is what precipitated the FDA to take it up. It was at the behest of Consumer Union, Consumer Reports, after doing its very exhaustive consumer survey, that they said it's time for the government to step in. And that when it comes to all natural, Consumer Reports has taken the position that companies should not be permitted at all to use it because it has caused such confusion in the marketplace.
Yeah, I don't even think it's caused confusion, to tell you the truth. I think consumers probably are pretty clear on what it means. It's just that nobody's complying with that. I saw I don't know whether you're litigating any term other than natural, but I just grabbed this statement out of your papers that 2/3 of consumers believes that the term no nitrates means no nitrates. I mean, what else would it mean?
That's right. And
like, I would think that if it says no nitrates, that there's no nitrates.
right. And oftentimes, the companies then qualify it elsewhere. Same with antibiotic-free, wherein you see oftentimes this qualification that consumers don't see from the outset, that they say no antibiotics in perhaps the product itself, but nevertheless acknowledge that perhaps during the process, antibiotics are being used. And so there is case law with regards to disclaimers not necessarily absolving companies from their overt deception. And so we very much litigate accordingly. And so I think that, yes, just because, say, a company uses, say, celery extract, can they frankly say no nitrates if it nevertheless has the same ill health effects and still causes, certain public health issues? So it's, frustrating, but they know. The companies, frankly, have, I would imagine, the latest research, market research, et cetera, when it comes to what consumers believe when they see all natural, antibiotic-free, nitrate-free, et cetera.
Yeah, you brought up an interesting point, and I don't know whether this is part of your litigation, but I mean, obviously, I wouldn't be buying these products because I don't consume them. But if I saw in another context no antibiotics, that would be important to me because I care about the development of antibiotic-resistant bacteria. So even if there weren't antibiotics in the residues in the product itself, I would still consider that a plus, that no antibiotics had been used in producing the product. Is that part of your litigation, or is that getting too far afield? Are you just going for the residue question?
Well, to be clear, the case has no personal injury claims. While, of course, this nevertheless addresses larger public health issues, we do not have any personal injury claims. And that is, in fact, by design, because what you often see is that then it becomes a real battle of the experts. And then, of course, the science that folks rely upon, whether it be, say, in this case, antibiotic resistance issues, can quickly become perhaps politicized, and then it's going to be perhaps years on end before the science becomes more established or depoliticized, and then the government would ultimately act. And so, with regards to how we have threaded this needle, it's really in the end not personal injury claims, although, of course, public health, animal protection, environmental protection are indeed the subtext here. And so the fact of the matter is that the forms of relief as well that we're seeking here, namely monetary relief versus injunctive relief, is also not perfect. Oftentimes it is these large monetary settlements that send a message to the industry, but the nature of these cases and how they are pled only are seeking injunctive relief. And so I can talk further about, precisely what is our prayer for relief, and explain how this is, yes, only one piece of the larger puzzle in terms of reforming industry practices.
Yeah, no, I do want to talk about that, but I do want to get to something. I just want to pick up on something you said, which I think would be of particular interest to our listeners. And that's, you're making a claim about potentially adulterated products, but are you also getting into the question of what natural means vis-a-vis the way the animals are treated? And what consumer perceptions are about that?
That's right. And so if you frankly look at the, organic scheme, people buy organic, right? Because not only is it perhaps healthier, right? It's also because of how it's being grown and manufactured and processed, et cetera. And so, similarly, with regards to all natural statements, we are targeting not only the product at issue and what's in perhaps the product, but then also the process. And so how indeed are the animals being treated, how it does impact the environment, how it perhaps even impacts the farmers and the workers in the processing plants. And so we have, taken a very broad-based approach in addressing these issues, and not, simply addressing animal protection or just simply human health or the environment. As we all know, there is a real interconnection between all those. As Rachel Carson said, right, what we do to our environment, we do to ourselves. And so the complaints have all been drafted to that end. There is perhaps more work to be done, I believe, with regards to food justice and labor issues, and connecting the dots further. But for now, we're doing what we can to address these other real concerns of public health, animal protection, the environment.
Yeah, of course. So, I mean, all the law can do is take the one step that's in front of you. You can't fix everything. But that does bring us to what you were speaking of before, and your prayer for relief and what you're seeking here, and how that fits into maybe a broader plan on how to address some of these issues.
So this is just one piece of the puzzle. There are multiple campaigns that a lot of our nonprofit clients engage in, whether it be social media campaigns, direct action campaigns, etc., legislative campaigns. And this is just one other piece of the puzzle. And this is simply litigation being used, ideally, to further policy and reform. And so with regards to the work here, hopefully it does, in fact, send a message or provide yet another tool in the toolbox for folks to, move the needle further, to have a food system in which the food is not tainted or adulterated, that the data set, while it identifies contaminants in the parts per million, parts per billion, that we know that it has a bioaccumulative effect, that it can cause antibiotic resistance, multiple levels, etc., that we would hopefully be part of a larger, puzzle, larger solution.
Yeah, absolutely. Well, that's all any of us can do. When the problems are this big, we can only chip away at the part that's in front of us. And I'm really excited that you're chipping away this particular piece of it. And I want to ask you about next steps in the litigation itself. But before I do that, is there anything that I should have asked you that I haven't that you'd like to add?
Other than the fact that this multi-pronged approach, I think is key. That oftentimes what we have found is that once these cases are filed and the press perhaps picks them up, that it does send a smoke signal, and it's amazing the folks who come out of the woodwork. Whether it be folks who are pursuing, say, nuisance claims, right, or environmental law claims under the Clean Water Act or under RCRA, et cetera, that we all of a sudden learn of these other independent efforts. And the fact of the matter is that, we're all in our separate silos to some extent, but I think that often what we're seeing now in this day and age is where people are starting to really build broader coalitions and are collaborating in ways that I have not seen. Oftentimes, for instance, you see the animal protection folks in one corner and the environmental law folks in another corner. But in a lot of our work, we have people, quote unquote, crossing the aisle here and pulling together to really, build a even broader coalition.
Yeah, I totally agree, and it's really exciting to see that happen. And having said that, I just want to return to something I asked you, but it occurs to me I'd like to go a little deeper into it, and that is that you are bringing the animals into this, and that the word natural means something to people. when it comes to the way they think animals are treated, and that's one of the reasons they buy organic, and that's one of the reasons they see the word natural and think that there's something good here. What specifically do you think are your theories about what's happening to animals that people argue people would think is does not comport with the word natural? Or, there might be other words that you're focusing on too. We've only mentioned natural, but I don't mean to limit you to that. I think, sure. I know that's the main one you're focusing on, but what kind of things are these companies saying that is misleading to people about the way the animals are treated?
Sure. So I believe that we are indeed limited in terms of our truth in advertising theory. That if the products are simply sold without saying all natural, 100% pure, antibiotic free, then we would frankly have no basis for a claim. And so, with regards to that, it can only go so far in terms of addressing the larger problem here. Moreover, with regards to what we have found through our FOIA request and this data set, which, by the way, spans not only chicken and turkey, but also swine and cattle. And, of course, identifies dozens of various contaminants, again, ranging from human pharmaceuticals, antibiotics, growth hormones, heavy metals, pesticides, you name it. That this is only proof that these contaminants exist. As to how these contaminants ended up in the product or were part and parcel to the process is still, frankly, an open question. We have, of course, a number of theories that range from perhaps the water to the medicated feed to the air to illegal use of perhaps certain antibiotics. We really do not know at this point what is the source. We have been advised that it's perhaps all the above, but it's still a question. And we have heard, stories from folks who are either former employees or neighbors, et cetera, of why certain contaminants are indeed popping up. But until we perhaps finish, discovery or go to trial, will we ever, fully learn what's going on? And so, in terms of answering the question of how, in fact, the animals are being treated, it's still an open question. We have seen through our investigation that there are standard practices that when it comes to rearing animals is frankly the same for the very same products that they then say are natural. That there's really little distinction other than perhaps the use of, say, celery extract to distinguish, lines that purport to be natural versus not natural. And so, it's really still, of course, a question we all perhaps know in terms of the, treatment of animals in these concentrated animal feeding operations. And I think that this, has shown that, you cannot, frankly, run an operation on that scale without the use of these various antibiotics, et cetera. That, in other words, we have information not only with regards to the litigation that's on file, but with regards to, dozens, if not 100 or so plus companies in terms of these contaminants. That, in other words, what we have learned is that when it comes to conventional meat, there are some issues that need, further analysis, studies, and frankly, ultimately, government action.
Yeah, well, that's for sure. I mean, you can't fix this all by yourself, but I'm glad you're trying. And tell us about the next steps in these cases. How much motion practice has already occurred, and where are you in the litigation? I know it varies. There's a bunch of cases, so it might vary a bit.
Sure. So, look, all these cases, figuratively put these companies under a microscope. With the power of science, we were able to literally put them under the microscope. In the case of the data set, this is actually the work of government labs that are just collecting this information. However, no one's acting upon it within the government. And so unless it perhaps triggers some type of federal reg. So with regards to a lot of these cases, we have been successful making it past the motion to dismiss, establishing standing. We are winning these motions. However, of course, it's a long haul until we reach trial. There has been significant blowback. While over the course of my career, there has been the occasional threat of a counterclaim, defamation claims, or perhaps a Rule 11 motion for sanctions. But that has always been, frankly, the exception to the majority of my work over a decade. With regards to this line of cases, when it comes to the meat industry, it's almost the rule and not the exception, where we encounter some form of blowback or another. And it has been all the above, from threats of defamation claims, whether it be of our nonprofit clients and their First Amendment right to talk about their work with the press, to threats of defamation claims against the attorneys themselves, and threats of sanctions and countersuits, all the above. And so there has been, a real blowback, consistent with what, we have historically seen, whether it be with Oprah Winfrey or
Right.
Pink Slime. We have indeed seen this kind of, blowback. And it's been litigated. There was one particular matter in which a sanctions motion was brought against us because they have, in fact, conflated or attempted to conflate this legal standard and unlawful standard that we talked about at the top of the interview, and try to, frankly, I think, intimidate our clients and the lawyers from pursuing the action further. But we nevertheless have ultimately prevailed. And the court understood that not only did we adhere to our ethical obligations and Rule 11 standards of properly investigating the case, but that this is really also ultimately a question for a jury, and it's a question of fact, and that this is not, a administrative action. And so there have been also, yes, counterclaims in which we then, of course, push back with what they call anti-SLAPP motion, and that is in the process of being further litigated. And so that is really what has been occupying our time to some extent. But with this all being said, we're now proceeding forward with discovery, and we can start, answering the questions as to what exactly is going on. Why are certain contaminants popping up? Why, do we have, issues with regards to their all-natural representations?
Yeah, it sounds seriously playing hardball here. So it doesn't sound like a lot of fun, but maybe it means that what you're going to find out is going to be really something to find out. It certainly, I think without any question, it demonstrates what we said earlier, that they really want to hold on to this term natural because it means a lot. And that means it means a lot to consumers.
This is true. And then moreover, I think that the data set that we rely upon in part here with a lot of these cases does perhaps present an existential threat in terms of how they operate. As I was saying, when it comes to a CAFO, you can't operate on that scale without pumping the animals with antibiotics, et cetera. And so I think that, it's the fact that this really threatens the core of their entire business model. And so they will kick, bite, and scream in order to defend these cases.
Yeah. Well, it sounds like they're doing exactly that. Well, I'm very grateful to you, Kim, for bringing these cases. And I'll be really keeping an eye on how they play out. It's really fascinating work. And thanks so much for sharing it with us today.
Thank you, Marianne.
Thanks for joining us on the Animal Law Podcast this week. I hope you're glad you did. I thought that was a really, really interesting series of cases. We'll be back next month with a new show. In the meantime, if you do like what you hear here, please subscribe on Apple Podcasts or your favorite podcatcher. Consider leaving us a good review on Apple Podcasts or on Facebook or wherever you can review. And if you're able, please consider making a tax-deductible donation at ourhenhouse.org. Thanks so much for tuning in.